refrain from acting with respect to any particular legal matter on the basis of this presentation and should seek legal advice from counsel in the relevant jurisdiction. Prior results do not guarantee a similar outcome. Lawyers Committee for Civil Rights of the San Francisco Bay Area accepts no responsibility for any actions taken or not taken as a result of this presentation. Thanks for sitting through that. So now here's an overview of today's agenda. I will give an introduction of the work I do and a brief recap of the last session. Then we'll go over specific lease provisions that are relevant to the common issues tenants face. And we'll go through a process of understanding how your business ties to those lease terms, how to review those terms, and then how to negotiate for terms that work for you. And then I'll go over the possibility of terminating a lease, and then we'll round out with some final points and questions. But please chime in with questions as we go through this program. You can unmute yourself or you can type in the chat, whatever feels best for you. So for some background about Lawyers Committee for Civil Rights of the San Francisco Bay Area, we were founded in 1968 to dismantle systems of oppression and racism and build an equitable and just society. The lawyers and advocates work to advance, protect, and promote the legal rights of communities of color, low-income persons, immigrants, and refugees. We are assisted by hundreds of pro bono attorneys. LCCRSF provides free legal assistance and representation to individuals on civil legal matters through direct services, impact litigation, and policy advocacy. And there are 3 program areas: racial justice, immigrant justice, and economic justice. And the Economic Justice Program is committed to closing the racial wealth gap and empowering communities of color through legal services for entrepreneurs and policy advocacy. Our work leads to increasing business and economic opportunities that will enable individuals to have self-determination over their livelihoods and communities while advancing a more equitable economy. So I will go over some of the main points from the last presentation that was Intro to Leasing. So one of the key takeaways from the last session is that leases are contracts. When disputes arise in court will only look to the 4 corners of the lease to decide what the outcome of the case should be. And unfortunately, commercial tenants do not have many protections in California law. So again, the lease will govern what protections you mainly have. But when you are entering into the lease, it is important to remember you're not doing the landlord a favor. Your business or your nonprofit is bringing value to the landlord by renting the space. So remember that you bring a number of valuable things to the contract and make sure that when you are signing this contract, you are receiving some sort of benefit. We also discussed the different types of tenancies you can enter, the pros and cons of a long-term lease versus a month-to-month tenancy. And then now I would like to ask you all if you can remember any of the benefits the tenant brings to the deal. You can unmute yourself or type into the chat. If you weren't at the last presentation, if you have any thoughts about any benefits the tenant brings, you can still contribute with any ideas. I'm seeing in the chat there is revenue and exposure. Yeah, those are some really important things that the tenant does bring to the deal. Revenue for sure, there's the monthly payments. I don't know if you could unmute yourself and explain what you mean by exposure, because I think that could be a really important point. Or you could explain it in the chat.
Yeah, so just thinking about, like, let's say you have like a plaza and you're renting out units in that plaza. Of course, that brings exposure to the other surrounding businesses, but also, it could potentially bring in another tenant as well. Someone could be, I've definitely heard of scenarios where, someone came to a business to patronize it as a patron, but also may have been like a business owner themselves, or may have known someone that's looking for, um, a commercial space. And then, that I actually had previously gotten a commercial space that way. We came in for a massage and ended up becoming a tenant in the same building where I got the massage. So it's exposure. It could help fill a vacancy, or it could bring in more business for the other businesses that are there.
Thanks for sharing that. Yeah, that's a really good point. I didn't think about it myself, but yeah, there's definitely exposure. If you rent to a property, if you rent a property and your business is doing well, other people, other business owners are going to want the same idea and maybe even be part of that neighborhood. Um, and then there's some other answers from the last presentation. There is the revenue, the monthly rent checks that serve as what's known as passive income to the property owner. And then there's someone who's taking care of the property for the owner, and they're paying part of. Oh, sorry. Did anyone have anything else to say? Okay. Sorry, it sounds like someone had something to say, but you can always unmute yourself. But the tenant does pay part of the property taxes, the operating expenses, and other expenses. If that space isn't being rented out, then the landlord has to pay those expenses. So again, it's more than just the rent. And you're also providing a service to the 7th Street corridor that, if your business wasn't there, then that service wouldn't be there. Um, And then a second question is, why is it better for a tenant and a property owner to work together to build a lease? Some landlords might just use a template lease and then not make any edits to that lease, but it is better for a tenant and a property owner to build a lease that works for both parties. Can anyone share why that might be?
I feel like I took a negotiation class in my graduate program, and one of the things that the professor said was, anytime you're dealing with any type of negotiation, he said an ideal negotiation is one where both parties walk away feeling like they won. And so if it's one sided, if it starts off one sided, then of course one party walks away feeling like they weren't heard, or seen. So, anytime you're entering into a long term agreement, I feel like in any capacity, even if it's, on a personal level, I think both sides being heard and feeling like their needs and interests were considered is important.
Yeah, that's a good answer. Um, do you mind sharing what your business is? I don't know if you put it in the chat, but I can't really see the chat.
So I'm here on behalf of ACD, but I'm also a small business owner in the community, and I own a business called a small skincare and wellness business.
Okay, nice. Thanks.
So and natural bath and body care products is what we focus on.
Thank you. Does anyone else have an idea why it's better? If not, I can share some ideas that touch on the same the same thoughts that were shared, but a lease that's built for the tenant's need that also provides the landlord with their financial desires means the business is in a better position to thrive, which means the landlord is more likely to continue receiving that financial incentive. So, if you think about recycling, for instance, we've heard the idea where if one person decides that it's not worth it to recycle because they're only one person, and what change can that bring? And then we zoom out and we see that if everyone thought that, then no one would recycle and there would be a giant negative effect on the environment. So if everyone recycles and we know it's the beneficial thing to do, then we see a positive effect on the environment. And the 7th Street corridor is an environment. If one landlord is willing to make compromises to work with a tenant, then the tenant will bring business into the corridor, like the exposure that was mentioned earlier. And if all the property owners in the corridor worked with their tenants, then the entire environment will flourish. So the end goal in mind is for both parties to enter into an ethical, mutually beneficial contract. That way, a beautiful community can be sustained. So we can now move on to the specific provisions where we'll go over preparing, reviewing, and negotiating. So before you even think about reviewing or negotiating leases, think about your business or your nonprofit and what are your needs specifically, such as your budget for commercial spaces, along with employee wages and inventory. And also think about your spatial needs, such as square footage, if you need a bathroom, a kitchen, do you need parking? And then we can think about negotiations. And sometimes there is no magical negotiation tactics that can make a lease work for you. So you always want to consider walking away. That can be actually a very powerful tool in negotiating if the landlord sees that you are willing to look at other spaces. So we'll do this process with the concept of rent. So you want to understand your needs for your business or your nonprofit. You'll revisit your budget. There will be the typical idea of monthly base rent, but most likely you'll also be expected to pay a share of the property taxes, operating expenses, insurance, and other costs associated with running a business, such as paying for your inventory and your employee wages. So once you understand what you're willing to spend for the business and what you have to spend for the business and how much your business will bring in, you can really understand what your budget is on the commercial lease. And here's a quick rundown of how rent works in a commercial lease. So rent is the price the tenant pays to the landlord for the legal right to possess and use the commercial rental property. Typically, there'll be a provision that says base rent. It'll probably be one of the first few things the lease talks about. It's the minimum or stated monthly rent that the tenant pays regardless of revenue. And it can be based on square footage. It usually should be based on square footage. And then there'll also be a fixed increase to the base rent or any escalations, which is an annual fixed increase to base rent set in advance. And then throughout the lease, there may be things considered additional rent, which might be percentage rent, which is a percentage based on the sales generated from the business. And then there are things called operating charges, so expenses associated with operating and maintaining the property that benefit the landlord and other tenants, such as common area maintenance fees, which might be janitorial services, security services, the property taxes, and then property insurance. And then my colleague Hewitt Shankut has some additional insight to share about costs associated with the idea of rent.
Thank you, Bisma. So yeah, I just wanted to chime in here as we're kind of dialing into the rent provisions, because this is really one of the most important features from like a legal standpoint, and obviously as a business standpoint, when you're thinking about the expenses that's going to be part of this that you're what is also important to bear in mind is that a fundamental feature that sometimes gets it's not always included in the lease is the total square footage of the premises, essentially like your leasable space, right? Because that represents the actual the boundary lines upon which like your rent is supposed to be applied to. And what I mean by that is that the terms of negotiating rent sometimes can get unwieldy, where you have landlords sort of avoiding the necessity to define the square footage of the space so that they can just demand like a flat fee and just say, hey, like we think like $5,000 is what we're asking you to pay here. But it's really important to make sure that when there is a negotiation, that there's always that grounding term of exactly the square footage of the premises. And then when you're negotiating rent, to ensure that you're negotiating not just the total rent for the total space per month, but also the dollar amount per square foot of the space. So that often provides you more leverage to be able to negotiate for a more fair and reasonable rent that's representative of the area, and also the type of building, the age of the building, and then also to have some like comparative metric against maybe if it's a multi-tenant building, to compare the rents and just to make sure that there's that that reasonableness associated with the dollar per square foot that you might not be able to get if you're just talking about the total rent that you're paying, because that's always dependent on the amount of space you're renting. And then the other thing to bear in mind is that, so we have here under additional rent is that there's operating charges. And so that is with respect to the you know, the portion, you know, as a tenant, the portion of the building's total expenses that you're responsible for. And so again, that relates back to your total leasable square footage of space as it's compared to the total building square footage, and that'll always come out to, oftentimes it's either a ratio or percentage, and that is just consistently kind of applied to the total building expenses. And there's always a category depending on the type of rent that you have. So if you're only paying a flat fee for rent, and if it doesn't include any other operating or ownership charges for the building, then that would just be a gross rent lease. And you know, that might be common if you're not sharing a building with other tenants, but more often than not, there's always some feature of building expenses that's included in the lease. And if it's the three categories of the common area maintenance charges, it's generally for the upkeep of like the shared spaces. And then the second category often is the real estate property taxes that the owner is obligated to pay. And then the last category is the property insurance. So that's making up what's often called like the triple net expenses. The last note is that what's not on here and what we've been seeing more of, and we talked about this a little bit at the last training, is this other feature called load factor. And what that is actual rent, where it's like what the tenant actually pays for that's beyond just their leasable space. So it actually includes rent that is for a portion of the shared common area. So, you know, that gets a little complicated when you're calculating the actual percentage of the common load that is to be applied, because it's very separate. It's sort of like it's an additional expense for rent. It's not necessarily just the building expenses. You could also be responsible for paying the rent that's associated with the common area. And so definitely if you have something like that in your lease, let us know or seek out some legal counsel. But just as you are also reviewing leases in the future or even currently, it's probably a good idea just to make sure to look through your lease to make sure that that load factor hasn't slipped through the cracks, and that you're making sure to make sure that that's all calculated correctly.
Thanks, Hewitt, for sharing some other ideas of rent that might be written in your lease. I want to share a visual example of an addendum from a former client's lease that shows the monthly costs associated with renting the space. So the base rent was $17,500. But throughout the contract, there were other provisions that included costs such as insurance and property tax. And there were some other adjustments made throughout the lease too. And this example shows how the base rent provision can say the cost is $17,500, but then riddled throughout the lease, there are other costs. You know, the rent might be on page 3, and it might be, you know, one of the first 5 provisions. And then somewhere provision 40 will state the insurance, and provision 62 will state the property tax. So, you know, when you're looking through the lease and you think I can afford $17,500 a month, it can easily end up being $20,330 a month, which is a significant change. So you do want to read throughout the lease to see what other costs are associated with renting. And then think about the bigger picture of what it looks like 3 years into a lease agreement. So here's another visual to emphasize how monthly base rent looks like in a year. So if the base rent is $17,000, you've considered the operating charges and the percentage rent. So now you're paying $9,500 a month, with the total annual rent being $114,000. And then there's an annual rent increase of $1,000. So by the end of 2025, you're paying $126,000. And then by 2026, you're paying $138,000. And this isn't including camp fees. It's not including operating expenses, property taxes. It's not including your employee wages or your inventory. But if you understand your business needs and you review the lease thoroughly, this shouldn't look too jarring, and it should actually help you understand if this space is right for you or if this rent is right for you. And if it's not right for you, then you should always negotiate. And when you're negotiating, it's good to start with your value. When you have a space in mind and you are working with the landlord, regardless of the landlord's demeanor, they might be friendly, they might be cold, they might be intimidating, or just very, very professional. You shouldn't let those things affect the fact that you are bringing tremendous value to the deal. You're providing thousands a month to the owner, you're taking care of the property so it's not sitting vacant. And again, you're paying a share of other expenses like the property tax that would otherwise be the landlord's obligation. So having this as like your baseline for when you start negotiating will really help you to ask for the things you need. And if you are interested in lowering monthly base rent, one of the best things you can do for yourself is look for similar spaces in the area and see how much the rent prices are for those. And don't be afraid to ask the landlord to explain why they're charging the rent they are. If it's based on square footage, again, you want to measure that space and see if that's actually the space you're getting. If the rent is for this one space is $9,000, but all the similar spaces are $7,000, don't be afraid to ask your landlord to explain the difference. The justification may be that the space is newly remodeled, it has a new AC system or upgraded restroom, and you might think that that's not a good enough reason, and you can be informed in asking, instead of paying 9,000, I can pay 7,500. Still think about negotiating. And if you think those are good reasons, then again, you can still ask to lower the rent, knowing that the other places are going for 7,000. And a $2,000 rent price difference doesn't add up for the upgrades. And you can start thinking about renting somewhere else. Or you can negotiate on other terms. If the rent price is a sticking point for you, you can offer to adjust the other terms. So you might be signing a 3-year lease and the landlord wants you to pay the 9,000, but you want to pay the 7,000. You can ask for a 5-year lease instead. That way, the landlord is receiving more money in the long run, but you're putting up less at the front. So you want to see what provisions absolutely won't do for you and what you're willing to compromise on, and be willing to bring those to the conversation. And you want to remember to follow up in writing if any negotiations are made. So everything must be in writing. So if you are touring the space with the landlord and you're coming up with these negotiations, you want to follow up via email or text or whatever works, but something in writing. As you see here, the empowered tenant is following up saying, as we discussed in person, you want to add some specifics like, as we discussed in person on this date, at this time, we changed the rent from 7,000 to 6,000. And maybe the landlord would respond, yes, that's correct, and we'll be extending for 1 more year. Ultimately, the final lease is the governing document, but the landlord might not make the edits after every single conversation. So to prove certain terms were decided to be edited, you need that written proof. So when the landlord produces the final lease and those edits aren't made, you can pull up these emails and prove that the edits should be made. But at the end of it, you want to make sure that final lease has everything in it. So every provision you've agreed to, it's the final lease that needs to have that. Otherwise, usually the lease will include a provision that says all outside prior documents aren't relevant and that this contract is the entire agreement. So to make sure that those edits get made in the lease, you want that stuff in writing, but the final lease should have all those edits as well. If there aren't any questions about rent, then we can move on to going through this process with the repair provisions. But if you have questions, go ahead and unmute yourself or type it in the chat.
I didn't have I didn't have a question, but just a comment. Just to kind of further what you were talking about in terms of negotiation. know that right now, because of COVID and a lot of vacancies that have resulted in various types of spaces, a lot of landlords are more willing to negotiate because especially if they own multiple properties, more than likely there's vacancies in some of those other properties. And so they don't want to risk more vacancies, obviously. And so because of just that kind of enormous amount of vacancies that's on the market right now, they are more open to negotiating. So I would just say that now is the time to negotiate, whether it be a new space that you're looking into and possibly even renewal of an existing space to leverage what's kind of happening right now in the marketing in the market as an opportunity.
Yeah, that's a good point. Thank you for sharing. The landlords might not have the demeanor, or they might pretend that that isn't the case. But facts are facts. If you're searching the properties in the areas nearby and you see these vacancies, don't be afraid to mention that and feel empowered. Because sometimes landlords say, that's not true, or I'm doing fine. But don't be afraid to poke holes in their demeanor. I see Sasha is raising your hand. You can go ahead and unmute yourself.
Can you hear me?
Yeah.
So I had two questions. One is what you mentioned about including like a written reflection of your conversation. Is that what happens if the landlord doesn't respond to confirm that written response? So that's one question. The second one is just wondering, as you're kind of negotiating a lease, are there, it can be a pretty meaty document. Are there particular places within a lease that are like hotspots that you should really be mindful of? Maybe that's kind of for future conversation.
Yeah, so to answer the first question, naturally some conversations do happen in person, and the best you can do as a tenant is to follow up in writing. And the landlord might not respond to that. But you're kind of just put in that tough spot where at least you reached out to follow up. And that's why you want to add specifics like, I'm following up because we had that tour in person today at this date, at this time, where we met at the property. You put in the address and you really outline what was conversed between the two. So at least when you get that final lease and it doesn't have those provisions that were meant to be edited, you have something to go off of. You have some sort of email that you sent, it's some sort of proof that we did have this meeting, we did discuss this, and hopefully the landlord, won't try to pretend that that conversation didn't happen, and you have something a little bit more forceful to show that those edits need to be made. But yeah, there are instances where the landlord doesn't respond to confirm, but it's still better to have something in writing. And then for the second question, I mean, I just as an attorney, I would say the entire lease is meaty and you have to read all of them. I think breaking it up into chunks is a good idea. I guess if you're not an attorney, again, think about your rent and the monetary things and read the lease looking for, skimming it to see what costs are associated with renting, and then go through it again, maybe another day to think about the repairs, and then another day to think about the duration of the lease, or think about the options to renew, which I'll discuss more. But maybe if you break it up, so when you're reading it, you're looking out for specific things, could be more manageable. But yeah, definitely read through the whole agreement. Hewitt, I see your hands raised.
Yeah, thanks, Bisma. I had something I wanted to follow up on Colette's comment, but then something came to mind as Sasha was raising some of those questions around like how to review a lease, especially when everything seems so important, like sort of how do you prioritize the review and kind of focusing in on the most, I guess, significant aspects and then going from there. Typically, a good place to start is just like what sections of the lease talk about tenants' actions to do or not to do something. And so that is useful to think of it from that vantage point, because when it comes time to address actual legal issues or disputes, often it falls down on, you know, either the landlord did something they weren't supposed to do or didn't do what they were supposed to do. And so as a tenant, if you are sort of in the beginning stages of reviewing your lease, because you're negotiating it and wanting to get one, or you already have a lease and you're trying to figure out, okay, well, how do I begin to put this lease into a framework that is, you know, clear and that I can follow? Often asking the question of what is the lease asking me to do and what am I prohibited from doing kind of helps. And so a big category, which we already talked about, is rent, because most of the legal disputes that arise often have to do with the non-payment of rent or some demand of rent payment that, you know, there's been a dispute over what is owed. So that's why we focused in on those terms. And when we talk about rent, like we said, there's all these other related features. So there's like the terms of like the time period, right? The time period, the life, you know, the total life of the lease, because that's pretty much like what's going to define the expiration date of when your obligations to pay rent goes into effect. So those are some ways to think about approaching how to navigate the lease. And then actually my primary comment was about negotiations, sort of how to position yourself in sort of this advantageous you know, posture, especially if you know there are vacancies. That's really powerful. As you said, Colette, at this time in post-pandemic space time, there's a lot of that happening. But being able to do some research just to support your offers or your counter offers, especially on hotly negotiated terms, and being able to do even some basic internet searches on what average rents are, you know, for commercial properties such as your own, if you, depending on it being retail or office or restaurant or industrial. And then also talking to other tenants is so valuable. If you're in a multi-unit, if you're in a multi-tenant building, and just having that information, exchanging that information, getting a sense of the baseline, and being able to use that to support your ask can also be very compelling in my experience.
Yeah, thank you for sharing. I think that's a good point. Is just being able to share with other tenants when you're negotiating, so you can see whether or not the landlord's demeanor is really something that is just a front, and that you can get the terms you're asking for. So when you're thinking about your repair needs, you need to, when you're reviewing the lease, or when you're thinking about your business, you want to think about your current business needs. You know, do you need a fully functional kitchen for your business? Do you need a bathroom? Do you need a garage or parking? But you also want to think about the space that you're looking at and its current needs. When you're touring it, does it have any repair issues before the time of signing? Has the space been inspected to make sure that it's ADA accessible, which means that it's accessible to people with disabilities? You want to see if there's anything that, if you were to sign the lease, that before you were even possessing the property, is there an issue that's now going to be your responsibility? And then you also want to see if issues arise in the future and there's other units involved, how will the lease address the repair responsibilities? Is your plumbing connected to an upstairs neighbor? Is there an AC connected to a neighbor where you're going to also have to pay for the electricity that comes from that? You want to think about that bigger picture when you're determining whether or not this lease in this space works for you. And the lease, you should identify who is responsible to repair and maintain the property and what they are responsible for. So when Hewitt was talking about reading through the lease and seeing what action items you would have to take and what actions the landlord has to take, the repair provision is a big place where it'll outline who's responsible for what. And typically the landlord is responsible for maintaining and repairing the structure of the building. So kind of the exterior, the systems and the common areas. And then all other repairs and maintenance on the premise are the tenant's responsibility. So usually everything contained in the interior. So walls, fixtures, lighting, carpet, things like that. And then in addition to outlining who's responsible for what, the repair provision should also have a right of entry clause that allows the landlord to enter into your space to make repairs. And you want to make sure that that right of entry is limited to emergencies. And if it's not an emergency, then the landlord has to give you some sort of notice, either 24 to 48 hours before. If they're bringing in a construction crew that could interfere with your business, you want to make sure that there's a clause in there that allows for some rent abatement or some longer term notice. And then something else to note is that repair is different from tenant improvements. So if you're touring a space and it doesn't have a functioning kitchen, but you need it to, and you and the landlord agree that you'll build a kitchen and you and the landlord will determine who's paying for what, that would be considered tenant improvements and not a repair. And so that will come with its own host of provisions that would need to be reviewed. And then I wanted to share what is a provision in some template leases. Some landlords like to offer a template lease that includes a provision like this, which basically says that the landlord is maintaining the exterior, which can be seen in paragraph B. And then paragraph A has an option that lists all the things inside of a building that are like the heating, the air conditioning, the electrical, the plumbing, and the water systems, things like that. And if the box isn't checked, then the tenant is responsible. If the box is checked, then the landlord is responsible. So again, even with these template leases, you want to make sure that you're reviewing it and things get checked. And then the biggest issue with repairs isn't so much what the lease says, but it's about enforcing the provisions. So sometimes the lease will be very tenant friendly and there will be a repair that's needed that is the landlord's responsibility. And in some of these instances, the landlord might just ignore the repair request or even deny taking responsibility. So what you can do to enforce this provision is, one is that you want to read through the lease and see what your responsibility is in informing your landlord about the need for the repair. Because oftentimes, even if a repair is the landlord's responsibility, you might still be responsible for notifying the landlord in a specific way about that repair. So you want to make sure that you've crossed your T's and dotted your I's and mailed in that notice to repair, even if usually you talk to your landlord over text or phone call. But if the lease says you send in some sort of certified mail in instances like this, then you want to make sure you've got yourself covered. If the landlord is still denying and they're still, ignoring the repair request, it's a good idea to retain an attorney to send a demand letter. And in that letter, they can cite to the lease, they can cite to other relevant authority saying, this is your responsibility. You need to take action, you're in breach of contract. And if your landlord is, for whatever reason, bullying you for asking for these repairs, maybe they're even threatening to evict you if you bother them about these repairs, then you need to let your attorney know so they can include in that demand letter some more relevant language. Because again, even though commercial tenants don't necessarily have a lot of rights, you as a person do. So if they're harassing you, then there is penalties for that. So the landlord can include that in the demand letter. If they're threatening to evict you for asking for repairs, as a tenant, you do have that right against retaliation for asking for repairs. So there's citing to the lease and then the relevant authority and including any punishments that the landlord would include in that letter. And that can be a very scary letter to receive from a landlord. Maybe they're just, being cheap and they don't want to make the repair, but it's going to be much more expensive to get sued over this and to get a letter from an attorney. And then another thing you can do is file a claim because the landlord is breaching the contract. So you can repair so that you can make the repair so that your business can continue. And then you can file a claim for reimbursement. This would be expensive for both parties. You still do have to pay like a filing fee. It's expensive for your time because you have to go to court. But settlement is always wise for both parties. So if the landlord receives this breach, this claim of breach of contract from the court, it's in their best interest to sit down with you and get it resolved. And this way they know that you're taking it seriously, because if things were reversed and you were in breach of contract, the landlord in most instances are very quick to threaten a lawsuit. So, part of being an empowered tenant is making the necessary moves to make sure that your rights are being enforced. If there's no other questions about repairs, we can go through the duration of a lease and how to negotiate for that.
I have a question.
Yeah.
This is Melanie from the Alliance. There was a part that you mentioned around shared bills, potentially like to understand how that's set up with other tenants in a larger building. Is there usually some sort of clause that says, you know, if someone else is not paying their bills, that that doesn't get your your, you know, AC cut off, or like is there a way to that it makes it the ultimate responsibility of the landlord, the property owner, or you know, because I've heard some tenants are having to like kind of have these sort of back and forth with the other tenants in the building around who owes what, and so yeah, I don't know if you could speak to that a little bit.
Yeah, I definitely have seen that issue where you know, they're all sharing like a water meter, and the tenant is being asked to pay an exorbitant amount of the water fees, even though they don't use that much water, and it's because a neighboring tenant is using it. And I haven't seen anything in a lease that's friendly to the tenant, that's pro-tenant, that covers this issue. I have seen provisions such something about like a rogue tenant. So if another tenant in the space is misbehaving, that the landlord isn't responsible for that. And so this tenant, this client can't sue the landlord about it, over it. They have to sue and make a separate action against the tenant. So I have seen things like that. So if you have like a rogue tenant clause, you want to review it and, you know, really ask like, why is that even a need? But yeah, if you see that you're leasing a space that has these shared systems, then it's always a good idea to put these hypotheticals down in the lease, that what happens if the other tenant doesn't pay their share. You want to ask and include that you aren't responsible for that at the upfront. And if a landlord's negotiating in good faith, they should see no problem with asking for that. But I haven't seen anything like that actually in a lease. I don't know if you have.
Yeah, I can chime in a little bit. So I think it's important to distinguish between like utility charges, which is for just you know, like the general operations of the actual premises that the tenant is renting, versus like the actual common area charges, which are shared amongst all the tenants for like the collective usage of the building. And so for that latter part, that we can call the common area maintenance charges. So often the way it's structured, the payment of that, which is also a separate provisions that need to be carefully reviewed, is that it's usually structured as an estimate of charges that will be applied, and they should be specified and documented, whether it's for janitorial services or landscaping, things like that. And it's always projected. Those are normally like estimated charges for the coming year that the tenant is put on notice of. And then those payments are to be, you know, split up over 12 months. And then if there are adjustments that need to be made because of actual expenses being either more or less, then it's handled the next year as a form of credit or an additional request for payment to fill in the gaps. And the reason why I'm saying that is because usually landlords are, you know, the payment mechanism is a reimbursement that the tenant makes for charges that the landlord has already paid for. And so that's why, to get at that scenario, Melanie, is that if like there are, let's say AC, like for common area, often that's those are charges that the landlord is already paying, but then later on asking for a reimbursement. So my first curiosity would just be like, well, what is the structure of the lease? Like, how is the landlord going about paying for the common area charges? If, you know, they're waiting for payment before actually issuing the services, and that's a very odd structure, but definitely don't want to discount that might happen, and having some provision, usually in the lease, where it states that the landlord is also obligated to provide these services regardless of any other tenants paying or not, I think is really, really important to have that in there.
Yeah, I actually recall the situation now that they was one building and one tenant, and they separated into two. And so perhaps they hadn't done their due diligence around just creating like a CAM. So there was this confusion around, okay, now this new tenant is here, what's shared, what's not. So yeah, that it was a mess.
I can definitely see how that then could turn into the obstacle that you described, because then it relates to utilities that were once the tenant's obligations, and then all of a sudden it got split up. And so, yeah, definitely increases more conflict when, stuff like that happens.
Yeah, thanks for sharing that story. I think it just goes to show how unique every tenancy can be and why it's so important to get, the written leases adjusted to represent these things. Because you might not even know that an issue exists until it happened, and you don't have a lease to help address it. So it's good to think about all the wild scenarios before you sign a lease. So I'm going to go over duration of a lease, which basically means the length of a lease. So when you are looking to sign a lease, you want to understand your needs. We went over this at the last session, so I'm just going to give a quick overview. But if your lease is month to month, that means every 30 days. Your lease isn't guaranteed past those 30 days. Either you or the landlord can terminate the tenancy with a 30-day notice. Which makes it really easy to vacate if needed. If there is a repair issue and no party wants to pay for it, then, you can send a 30-day notice and leave. But again, there's no security for making long-term plans for your business there. And if you have a longer term lease, like a 3 to 5 or a 10 to 15, then you are locked in for those years. You've signed a contract, and maybe there's a way to get out of that contract, but it's gonna not be without its obstacles. And so, you want to make sure that the provisions work for you for this length of time. And you can become a neighborhood staple and make long-term plans. But again, you might have to leave at the end and start over or renegotiate a new lease to stay at the property. So you really want to determine what works for you at your business in that moment. And if you are operating on a month-to-month or even a short-term lease, like a 2-year lease, and you want something longer, these are some ways that you can negotiate for that. If you've proven to be a reliable tenant, that means there are reliable rent payments going to the landlord. And if you're willing to lease for longer, that means your business is proving to be successful. And so your landlord should want to continue leasing to you rather than to leasing to an unknown business, an unknown tenant, where it's harder to gauge whether or not they'll still receive those consistent payments. And if you go from month to month to something longer term, there's less of an opportunity for the space to become vacant. And a vacant space means the landlord has to pay for a real estate agent to get someone to find a new tenant. They have to pay the property taxes. They're losing money if the space is vacant. And it's also an opportunity to determine responsibilities and avoid continued ambiguity. If you're on a month-to-month lease, again, there's no provision that discusses repairs. There's no provision that discusses increased rent every year. So this is an opportunity for both parties to get more from the deal and put it in writing. So these are some ways you can ask for a longer-term lease. And if you're looking to lease a space and the landlord's offering you a 10-year lease, but you're not ready to commit so long-term, here are some things that you can do to get it shorter or to be more comfortable with signing a long-term lease. You can request that there be a mutual early termination clause to be included in the lease. So, if 3 years down the road, you're thinking, I can't be in this lease for 7 more years, it's just not working for me. You can request that there be this clause that allows both parties to terminate the lease. The lease is a contract, so the landlord's not going to offer this clause just to be included without some parameters, but you can discuss those parameters. And I'll go more in depth about what that'll look like a couple of slides later. What you can do is offer instead to sign a 5-year lease with options to renew to total 10 years. And an option to renew just basically means that at the end of the 5-year lease, if there is an option to renew, then you can just exercise it. You don't have to request the landlord for permission. You just can continue renting if you've notified the landlord that you are exercising this option. And you can make enough options so that it totals 10 years. So both you and the landlord can kind of have that sort of compromise. if the landlord won't budge on the lease duration and you still want to rent to the space, you still want to rent the space, you want to make sure you have a flexible sublease or assignment clause, so that if 3 years in the lease you can't do it anymore and you want to get out of the lease, one way to get out is to find a new tenant to take over the lease, which would be an assignment, or you want someone to take over the lease for a little bit, that would be a sublease. And a lot of sublease and assignment clauses come with application fees because the landlord does have to do some sort of background check, some sort of check to make sure that that new tenant can afford the lease. So what you want to do is make sure that there are no application fees. And if there are application fees, that they're a reasonable amount. I've seen application fees be $100. I've seen them be not to exceed $4,000. I've seen sublease and assignment clauses that allows the landlord to retain an attorney to oversee this sublease or assignment, that the tenant has to pay those attorney's fees, which basically makes it very difficult for you to feel comfortable even engaging in this process. So if you're signing a long-term lease or any kind of lease, really, you want to make sure you have this flexible sublease and assignment clause so that it can actually be a productive, a realistic option for you if you need to leave. And then I'll explain more in depth what an option to renew is. It's a powerful way to control what happens after that initial lease term expires. So it's an option to extend the lease for a specific term at a specific rent or the fair market value, which will be negotiated at the time of signing the original lease. So an option to renew basically means if the lease is 5 years and you have one 3-year option to renew. So when the lease expires after those 5 years, you will notify the landlord you're exercising your option, and then so you'll have 3 more years left on the space. And then the rent for those 3 years would have already been agreed to when you first signed the 5-year lease, and all other terms would have already been agreed to. You can always choose to amend those terms if you've decided some other things work better for you, but for the most part, there's no need to negotiate. You don't need to request any permission. You just notify the landlord within a certain time frame that you're exercising the option, and then you continue renting for 3 more years. And you can have multiple options to renew. And so it's a method for securing the possibility of renting a premise for a long term without really being tied down to a long-term lease. And so here's a visual of what that looks like, of 2 possibilities to exercise your option. So if next year you sign a 5-year lease and you have 3 5-year options, you can keep exercising every 5 years until you run out of options. And so you can be there from 2025 to 2045, but you're never expected to be at that space for more than 5 years. Or after the first lease expires and you exercise the first option, in 2035, you could decide, I want to move to a different location, or I don't want to run my business anymore. You can always just not exercise the option and relocate or no longer operate your business, and you're not penalized for that. There's no penalty to not exercise your option. So these are some ways to get different lengths in your lease. If there's no questions, I can move to early termination clauses. Okay, so I'll move on to the benefits of having an early termination clause and then the downfall of not having one in a lease. So if you do have a lease with an early termination clause, then if the certain parameters of that clause arise, then you can end the lease without being sued for breach of contract or for abandonment. And so some parameters could be that before you sign a lease, you can discuss that you can terminate the lease early in case there's some sort of major reconstruction needs. If the property gets completely damaged in some way, if the property looks like it's going to be sold during any point in which you're leasing, you can ask that that's a reason for you to terminate the lease early. That's a really important thing to think about when you're leasing a space is the property going to be is the ownership of the property going to be transferred? Because when there is a transfer of ownership, there is a reassessment of the property taxes, which means that the taxes will be higher. And so that will affect how much money you're giving to rent the space, essentially. Or you can include government closures, such as something like COVID-19 shutdowns happening again. You can include that if a government shutdown happens again, then both parties can agree to terminate the lease. And so what happens if you don't have a lease with a clause that allows early termination and you need to leave the space? There can be some serious penalties. One is the risk of litigation. You could be sued for abandonment or breach of contract. There's also financial penalty if your landlord has to sue you and there's grounds to sue you, and if they win the case, you will have to most likely pay their attorney's fees. You'll also be responsible for the remaining time left on the lease. The landlord does have a duty to mitigate if you abandon the premises, which means they can't just sit around and expect you to pay rent for however long is left on the lease without actively looking for a new tenant. But again, maybe they just don't find another tenant for another 6 months and there's 6 months left on the lease, then you're still responsible for paying that. If you signed the lease as an LLC, but you might have also signed a personal guarantee, then if the landlord is suing you, then your personal assets are still liable through that personal guarantee. And then also there's the negative impact on your credit score and your tenant history, which will make it harder for you to rent another space. So these are the penalties that come with terminating a lease early if you're not able to come to an agreement with your landlord. And so what that looks like to come to an agreement with your landlord if you need to terminate a lease early and you don't have a clause that allows it, is you can agree to sign a mutual release of obligations of the lease. So that's basically a document saying, you know, the lease isn't expired, but we're making it end early. And to get your landlord to agree to something like that, you do have to offer some things in exchange. It could be the forfeit of the security deposit. It could be a lump sum of cash. It could be some inventory or assets that you have for the business. So if you have like 3 months left on the lease, then maybe offering the security deposit is enough. If you have 5 years left on the lease, you're going to have to offer a little bit more, but a lot more than just the security deposit to get your landlord to agree to something like this, because you know they have a contract, they're in the legal right to enforce that contract. So you do need to find things to make it worth their while to agree to this mutual release. Another thing you can do is find a new tenant willing to take the space. So that relieves the landlord of that duty. That relieves the issue of the space remaining vacant. And if you do both these things, hopefully your landlord is more willing to come to the table and end the lease early. So I can share some final points and then we can get any more questions asked. So if there are questions right now, you can always unmute yourself too. But one final point I want to share is that before you sign the lease, I would hope that you imagine the worst case scenarios when you're reading the lease. Because these things, you know, maybe they seem like they'll never happen, but they do happen, and that's why, you know, my job exists. So one of the things is you want to read the attorney's fees clause or any other costs associated if a worst case scenario happens. So if the worst case scenario of the landlord suing you happens, you want to think, are there fees that you have to pay for that lawsuit? If the landlord wins the lawsuit, do you have to pay their attorney's fees? Or is there any circumstance in the lease that allows the landlord to hire an attorney that you have to pay for? So for instance, if you're looking to find someone to sublease the space and the landlord's allowed to retain an attorney that you pay for, you want to think about that scenario. You also want to see if the lease has any waiver of your rights. A lot of leases will include some codified language, some civil codes that are included in the lease because you're waiving them. It'll say tenant waives civil code, and then it'll be followed by some numbers. And it might not even explain what those codes are. So it's good to do some research and look it up. But you want to see what rights you're waiving. Are you waiving your right to a jury trial? So if you are sued for, you know, let's say eviction, is it a judge that will be deciding your case or a jury? And again, in the worst case scenario, you want it to be a jury, you want it to be peers, because oftentimes judges might be more akin to property owners. They might see, that side more than they see your side. So you want to see what rights you're waiving. And again, you want to think about the transfer of ownership. Is there a possibility? Is there, the worst case scenario, is your landlord a very elderly person? Is there the possibility of them passing sometime during your tenancy? Because then the taxes will be reassessed and will increase. Is it a realty company that owns the property that's interested in selling the property? Again, your taxes will be increased. And then you want to think about the economy. It's hard to gauge what it could be, but especially now with elections coming up, there's all sorts of turbulence. So you want to think, if the economy gets even worse than it is, can you continue to lease? Can you continue to operate the business? Do you have an early termination clause? Is subleasing and assigning an option? Does your lease allow for mediation before anyone can file anything in court, before there's an unlawful detainer case, which is an eviction? And if that's the case, then again, who pays for that mediation? And things like that. You want to think about all these worst case scenarios before you sign. And then you want to think, or you want to remember that everything is negotiable and everything should be in writing. So you want to remember your value when you're negotiating things. The landlord gets the value of someone paying for the property and taking care of the property. You're bringing a one-of-a-kind business to the 7th Street corridor, positively impacting its environment. You want to get everything in writing. Any conversation over the phone or in person must be followed up in writing to prove those conversations happened so that they can be included in the written lease. You want to understand your business's needs, their current needs, the future needs, before you can really even think about signing a lease. Think about what you can compromise on. And everything is negotiable. Landlords use terms like this is standard, this is typical, this is form, this lease can't be edited, but everything can be edited. Everything can be changed and revised. And, sometimes it might be better just to bring that, if you want to edit a provision, sometimes it's best to bring some language that shows what kind of provision you want to replace the provision that's not working for you, to make it easier on the landlord. Just do their job for them sometimes, so that they are more willing to change things, but everything is negotiable. And then lastly, to keep the 7th Street corridor a healthy and robust environment, we need empowered tenants at the root. Then we also need community-minded property owners who are willing to work with these tenants, that are willing to receive the benefits of what comes with renting a space without being predatory. And then the tenants need to be willing to share their information to each other and learn and build together and have that tenant solidarity, sharing the methods to the wins they receive. And so now we have time for some final questions, or if you'd like a moment to share any insight and spirit of tenant solidarity, I welcome it. Sasha, I see your hands raised.
Yeah, I guess I was just gonna say, a lot of this content feels like it's to accommodate a new lease. So this is like before you've signed your name on the dotted line. But I'm wondering, what happens or how to think about these tools that you're offering when you've already signed the lease. And so you're already kind of in a binding contract that may or may not be as you wish you would have negotiated because you didn't get to learn from LCCRSF before you signed that contract.
Yeah, that makes sense. Usually people are already in a lease when they come to us. It's trickier to be empowered when you're locked into a contract that isn't empowering. So I don't know if you have any immediate thoughts while I think about that.
Yeah, I mean, I think fundamentally, like negotiations can happen at any time of the life cycle of the lease, even if you have already entered into a binding contract in the lease. There's nothing to stop a tenant from going back to the landlord and asking if they would revisit certain terms. And definitely recognizing that, you know, many on the call and some of you, we've even had a chance to learn more about the dynamics of your current commercial lease with the landlord and the disputes that exist. You know, there is a container within negotiations that can still possibly allow for revisiting certain terms. Now, negotiations are entirely voluntary and it requires two parties who are willing to cooperate. That's not always the case. In fact, more often than not, you're dealing with a very hostile landlord. You're already locked into a lease. Maybe even your lease
You're
says,
cutting out a little bit.
oh, sorry about that. How about now? Can you hear me?
I can hear you. It was fine for me. I
Oh,
don't
maybe
know.
it's me.
Yeah.
Okay, maybe
Okay,
it's me.
yeah.
I'm
Well,
sorry.
the scenario that I think is even more difficult is where, you know, you're already in a situation with a landlord who's completely uncooperative. And also, maybe you have a lease that has since expired and you're on a month to month. So it's not so much of a clear path to try to, you know, even get another written document on the table because the relationship has already broken down with the landlord. In that instance, a lot of the things that we described in this presentation, that's all predicated on negotiations between two willing parties, might not actually be applicable to you. And in that case, it would require escalation. And so you would move out of the realm of negotiations and actually have to seek out legal remedies in court to essentially either compel landlords' compliance with some of the basic rights that are available to you, whether it's under you know, civil rights codes or other codes that might be relevant to you as an individual. If there is harassment going on, you know, it would all be case specific. But even situations with respect to maintaining the building, right? We would have to look beyond sort of commercial real estate laws to see if maybe there are laws with respect to health and safety code violations or you know, other laws that might actually implicate liability on property ownership obligations that the landlord has. We have to get creative and look outside of the commercial lease. And these are all things that we can consult on and try to get a better sense of exactly what problem or what obstacles you might be facing as a tenant in this situation. But we may have to actually consider lawsuits. We may have to consider escalating things from negotiations to actual litigation because, you know, you're in a scenario where the relationship has broken down to the point where negotiations are not feasible. And so with that, we definitely want to reiterate that we have office hours with the attorneys on the team, Bisma and myself, that are coming up next week. And I don't know if we have folks who are interested in that, but we definitely have that available. And so there will be information on how to sign up for that. And if that, you know, even beyond that too, just make sure to share our information with you all so that there's a way to get in touch with us if there are sort of other disputes that are happening right now that are beyond the realm of sort of a negotiated settlement.
Thanks for highlighting the office hours. Yeah, I thank you all for your input and your questions. Yeah, so everything is negotiable at any point. We've already signed a lease. You just have to be mindful of the penalties and the parameters of the lease. But like Hewitt said, you know, it might have to get escalated. And there are attorneys available to assist you. So if there's any other thoughts or questions. If not, then thank you so much for joining, and I hope you guys can come to the next presentation about your commercial tenant rights. There are updates, exciting things within the past just couple of months of getting more rights. So I really hope you guys can make time to come to that one. I don't remember the date.
October 29th.
October 29th. Thank you.
Yeah, no problem. Same time.
Thanks, Pisma. Thanks, everyone. We'll be in touch over email. I don't know if you have anything else to share, Sasha.
I don't think so. I believe we've done a survey of the last training. So would love to just get folks' feedback so that we can continue to either make adjustments or just be mindful of needs. Melanie sent that around, and I know we could send it around again. So yeah, it would be great if you haven't already and have the capacity to respond to the after training survey. That would be amazing. And then we had raffle winners as well. So definitely want folks to collect their prize. Thanks, Hewitt. And let's see, I think maybe the other piece is just, reach out to any of us, Alliance for Community Development, myself, Lawyers Committee for Civil Rights. If you just have any questions or you feel like, I need more information, there's always space for us to determine what's the best path to support you.
Thank you, everyone. Have a great rest of your day.
Yeah, thank you so much.
Thanks, folks.
Bye.
Bye.